Today, Luigi Mangione is expected back in a courtroom. He'll be in federal court where he will enter a plea on stalking and murder charges. The most serious charge, murder through the use of a firearm, could get him a life sentence or send him to death row if convicted. Just hours before this hearing, federal prosecutors submitted formal notice and paperwork that they intend to seek the death penalty. And Mangione is facing all of this related to, of course you will remember, the brazen shooting death on a New York City sidewalk of the CEO of UnitedHealthcare, Brian Thompson, back in December. Mangione also faces state charges in New York and Pennsylvania related to the shooting and the week-long manhunt that came right afterward. Joining us right now to talk about today and all of this news coming in is Bob Bianchi. He's a criminal defense attorney and host of the Law and Crime Network. It's good to see you. This latest move, let's start there, with DOJ filing notice that they plan to seek the death penalty. Is that surprising to you?
Well, Kate, as a former homicide prosecutor, actually where I started my career, this is not surprising to me at all. This is the prosecutors getting together, hopefully playing well in the sandbox and leveraging the power of each jurisdiction to apply as much pressure as possible on the defendant, hopefully for a resolution of the case. When I used to prosecute death penalty cases, sometimes the charges were filed in conjunction with other jurisdictions. Again, applying the direction of the case in a different way for defense lawyers. Instead of just trying to say he didn't do it, he's not guilty, or defense, now they have to look to save his life. And that is a completely different defense. So this application of these additional charges, and now with the ultimate punishment, possibly the death penalty, puts the defense in a very, very difficult position. So strategically, very smart by prosecutors.
And as Reuters is reporting it and justifying their decision, prosecutors wrote in their filing that Mangione, quote, presents a future danger because he expressed an intent to target an entire industry and rally political and social opposition to that industry by engaging in an act of lethal violence. You talked about what this approach now does for the defense. What does it change for prosecutors? How hard is this, what they just presented, to show in court, and what it means for their approach to the trial now?
Well, prosecutors have to be extra specially attentive when they're seeking the death penalty, because there's going to be more scrutiny and review by the appellate courts down the road. Now, listen, here's how I used to look at it. I'm not a big fan of the death penalty, even though I used to prosecute those cases for multiple reasons. But if you have a death penalty, it is a law, it's on the books. The question as a prosecutor becomes, in which cases do you apply it? In which cases don't you apply it? And the prosecutors here are saying, and not surprisingly to me, that if there's not a case for a death penalty, this certainly is the one that screams out for it. It's planned, it's premeditated, it's an attack on an industry, it's there to make a message. This wasn't a spur of the moment thing. And essentially, prosecutors are going to argue that the ultimate penalty, the death penalty, is appropriate in a case like this to deter people from trying to advance their political causes and their political issues at the end of a gun, as opposed to the voting booth or the legislature. So this kind of is the kind of case that prosecutors will pursue for that reason. But now they've got to make sure, when you have two jurisdictions prosecuting, that they're playing well in the sandbox, that their egos are not getting in the way of doing anything that could jeopardize the case. Because when it's the death penalty, appellate courts are going to be extra special attentive that it was done correctly. Again, because if you execute somebody, you can't reverse that.
Yeah. And this has become so high profile, including the morbid fascination that he has sparked amongst, quote unquote fans showing up to support him every time he goes to court. You probably expect more of it today. You've been both prosecutor and defense attorney. How does the high profile nature in this dynamic around this accused killer, how does that impact the approach, if at all, of both sides in the courtroom?
It's a huge issue, and prosecutors made, in my opinion, an extremely bad tactical decision by doing their perp walk scenario with all that extra firepower. You may remember the images and all the law enforcement officers. They created a spectacle, and now they created an individual who is now being lionized by a significant section of society. Why does that bother me as a prosecutor? I got to worry about somebody on my jury pool being like that. It only takes one person on the jury of 12 to say, you know what, out of whatever political reason or becoming famous or because of the fanfare that he has, I am not going to say guilty. And if the prosecutors can't get all 12, then they're not going to get a conviction. So that purple backfired on them. As a prosecutor prosecuting this case, I'm going to be extremely attentive. I'm going to talk to experts, jury consultants, and I'm going to make sure my voir dire, which is where you can eliminate jurors with prejudice, is really squared away, because I got to worry about that one single juror. It's a strong case otherwise, but that's what I'm concerned about. And alternatively, the defense is going to work on that image with regard to his popularity in order to get that one juror not to convict him. Do I think 12 people are going to say not guilty? Not based on the evidence in this case, unless the evidence was illegally secured.
Well, it's all really important dynamics you're laying out there, Bob. Thank you very much for coming in. It's good to see you.